If you miss on that, the client will be paying very hefty fines, and obviously it will have an impact on your trust building also, because this whole field is built on trust, and you need to ensure that everything is according to the law.
Hello and welcome back to another episode of the Super Lawyer YouTube channel. Today we are delighted to welcome Punit Gaur sir. Sir is a dedicated legal advisor with extensive experience in global legal landscape, specializing in the US corporate law, high-stake arbitration, contract drafting, and the incorporation of businesses in the US. He brings a wealth of experience to the table. Sir has successfully advised clients across the US, EU, Singapore, India, Australia on compliance, employment law, due diligence, cross border risk management issues, among other areas, and we are absolutely eager to gain insights from his journey today. My name is Anshi, and I work as an associate with the Superlawyer team. At Superlawyer, we aim to showcase the inspiring journeys of legal professionals, offering valuable insights and guidance to motivate the broader legal community and empower our readers as they navigate through their careers. Thank you so much for being here with us today, sir. I'll request Ziva ma'am to please continue the conversation now. Thank you so much.
Hello and welcome, Advocate Punit Gaur. We are very excited to have you here today. Hope to have a lot of insights related to technology, arbitration, IP laws, other rights, and your own favorite engineering field. I am Divya Dwivedi, and I'm team lead at Super Lawyers. And we try and bring young and exciting souls who will talk about how they have reached where they are right now. Let's start with our very first and very important question. If you were an engineer already, how and when did you decide to become a lawyer? And what was the motivation or inspiration behind it? Now you are practicing not only technology law, you are also practicing privacy laws, data laws, everything and anything under the technology field itself. So please let us know how and when you decided to do this.
Since my BTech days only, I was very keen to learn new things so that if anyone comes to me, I can help them and solve their issues. And I don't even feel that it was a shift from technology to a legal landscape, because even I consider that part as addition of what I have learned from BTech days. So my technical background was very helpful. It taught me a lot of problem solving skills, and it especially taught me how to look at things very differently. Like I have at least two or three perspectives so that you can figure out to solve whatever is coming towards you. So legal also was an add-on to that, and it was an amazing add-on. And those skills that I learned from my legal college days and to the work I do, everything add up. And that's why I feel after spending so many years, almost more than a decade in learning, I am able to help my clients in a lot better manner than I earlier would have been able to do. And because of that also, now since the science field is taking up a notch in India and we have a lot of technology companies, I am able to understand what issues that they face and what kind of problems they are having. Whenever they come to me for any legal issue, I am able to understand that better and give them the proper solution that is applicable in their case. So it's obviously a add-on. Everything is an add-on, not a shift for me.
Amazing. So once you became a full-fledged lawyer, as you said, that it was an add-on in a very early stage of a legal career that you started working with a range of national and international law fields. Why were these formative experiences so important to you in order to understand how law is shaping the kind of trajectory in national format and international format as well? And I guess you'll be the best candidate to tell us about it.
Yeah, definitely. Because since even considering from my internship days from my law college up till now, also, every single time I have worked on something or other which is new, and always I felt like how I'm going to proceed with this, how I'm going to do it. But on the whole process of what I learned is you just keep learning. You just don't say no to anything. Just say yes and accept the battle what you get and just continue learning. So because of that, I have worked with so many law firms and so many people all around the world on very various different things. Like even considering litigation, I have worked on from the basics of check dishonors to commercial matters to going high up to the land acquisition and land compensation matters. I have represented NHI in that. And then continuing towards that, I have presented high stake arbitrations also, and also assisted some Washington based lawyers for their arbitration proceedings. I have drafted work for them. So I know how the litigation is working out all over the, at least not all over the majority of the countries. And the same goes for the corporate side also. I have drafted agreements and contracts for my Indian based clients, some EPC agreements which are required for whole engineering, procurement, construction, the whole big project, to MSA agreements. And then for some foreign companies, I have done data privacy. I've done their compliance work also. So I know what every other people are thinking before they come to a lawyer and what expectations that they have. So, working in all of these projects, I figured out that you need to be humble while talking to your client and let them speak, understand what their needs are, because that is the main object and you will get the pathway from it. Because once you figure out what client actually wants, you will be able to deliver the right kind of services to them. It's true in India also, and it's true outside also. The difference that I learned outside was the people are very punctual, and they are not only punctual, but I would say that they respect time. They pay you according to your time, and they want you to be ethical in every single process, whatever it's possible. So I have incorporated those learnings also in my drafting and my client handling process that I do in India. And a lot of things that I use in India also, like I learned doing legal research in a better manner in India, and how to approach a situation, how to search for a case, and what thought should go in your mind. I have learned from highly experienced people, highly experienced lawyers in India itself. And the same skills that I learned for legal research is applicable in US, and I'm able to deliver much better opinions in the US for my clients. So they also appreciate it, and this diverse range of things that I learn from everywhere, I try to apply it wherever it is possible, and it's always prove fruitful to have an acceptance to grasp new things and just keep on learning and learning.
Thank you so much, Mr. Puneet, for being so upfront about the comparison and importance of the time, the value of time, and not only the value of their time, they value your time as well. Let's move forward and try and understand other aspects of working in various jurisdictions. And you are currently actively working advising businesses across jurisdictions, which include USA, Singapore, as well as Australia. What are some of the key legal or regulatory differences that you may have seen or encountered thus far? And how have you brought yourself to effectively manage these kind of complexities in the cross-border compliances from where you are? Looking forward, not only drafting, but understanding the future consequences also of these drafts. How have you nurtured yourself with this kind of knowledge?
For this, I believe that whenever I worked in a jurisdiction which is new, I start to grasp whatever basic things that is required in there. Say I am required to draft data privacy policy for a EU based client, then there is a thought process which is different because you have to consider GDPR and they are a little stricter. So I'll give you a basic idea. What's the basic difference between all of the jurisdiction that I noticed? Because I'll cover different kind of laws that are having changes and not compared to only single one, because each jurisdiction, what I noticed, they have very unique laws. Some are having cultural considerations in them, some have great enforcement mechanisms. So each one of them requires very different strategies. Like in US, I would say the employment law is very largely at will basis because of the earlier discriminations that they have faced. So it is a great thing that I saw there, that at will employment is amazing. You can go whenever you want to, the company can also leave you whenever they want to. So they both have equal rights in that situation. They have also discrimination laws which are incorporated in the employment agreements and employee handbooks. So I love the part that how they approach any kind of discrimination and how to prohibit it and give people more rights for them. So that was a great learning from there. For EU, I saw that the GDPR is the most strictest data privacy law that exists in all over the world, and all other regimes are trying to utilize that GDPR only and just make changes according to their country. So the GDPR is the biggest thing for Europe, and you have to be very focused towards how to approach it and take it very seriously to figure out whether it's applicable to you or not. Now, even moving towards Singapore, I believe it's very business friendly, but has very strict anti-money laundering cases, and they have very good regulations, which should, I believe, also be incorporated in India. We have laws, but I believe Singapore is much more stricter in that sense, and they don't even care whether you are a billionaire or millionaire or whatever you are. Even you have done any kind of money laundering, they will put you behind bars. So in that case, you have to be in compliance for that, and it makes it a focus point in Singapore also when you are working for a company. So this becomes important when you're doing cross-border compliance for a client. Sometimes, say a client is based in Australia, and when I read their documents, we feel that only data privacy law of Australia is applicable. But when we have a conversation with them and figure out what kind of work they do, then we realize that they are also catering to European clients. Then GDPR also comes into play. And if we miss that part, then they will be liable for hefty fines. So in avoiding that, you need to understand. So it is a very helpful thing when you're working in different jurisdictions that you know something or the other about each of the place, and you can incorporate it in whenever you are working for a cross-border transaction. It's very useful, and definitely it'll build up on your thought process also.
So when you're talking about all these kind of draftings and negotiations along with arbitrations, different kind of high stake agreements also take place, which you deliver to these international clients. What kind of challenges have you seen thus far in drafting these agreements, such as SaaS contracts or NDAs for MSMEs? Because there are many, many times when, because of this, litigation or arbitration starts. So, how do you make sure that you not only follow the law to the core, but also make sure that they are very simple in terms in order to make everyone or anyone understand it if they read it? Even though they are doing a lot of business, that doesn't mean they will understand everything in law. So, how do you make sure that they are that easy for even the business person to understand? Please let us know.
Yeah, definitely. Say for the SaaS, NDA and MSA, as you mentioned, they are very critical for the business operations because they also not only focus on IP, but they also focus on service delivery, then their confidentiality and their liability also becomes an importance, and also all the other things around that. If you make errors in there, then it will definitely lead to financial losses and they will be engaged in long legal battles. So definitely that will lead to operational disruptions. We don't want that. So whatever the pitfalls that I feel that are present in whenever we are drafting or we see that the client is facing is some of them I'll mention, like one is having ambiguous terms in your contract. You don't clarify your clear obligations, like whenever we sit for negotiation between our client and the other side, and we have the discussion, we go everything and we figure out that whatever their goals are and whatever our goals are, but we fail to incorporate that in the contract, and we don't clearly mention the obligations. If we add on, say, too much legal jargons in there, then whenever the party is reading it, they will not able to figure out like what is this, and they're every time running to the lawyer. And sometimes they will be lazy or don't even want to go to a lawyer. They'll interpret it as what they want to and then cause problem. So whenever you are drafting, especially obligations or any other clause, something which the client is required to act on, it should be very clear. It should use very simple language. I always prefer using simple language, which any person can understand. Once the draft is ready, I add my comments in there, like go through the obligations. If you don't understand anything, please let us know. And in case we have probably too much obligations or less obligations, once you read it, you will know what we need to do. So it becomes easier for them. And from day one, whenever we are making the contract, they are also aware like the obligation is supposed to serve this purpose or this clause is supposed to serve some purpose. So they get very clear on this and it's very useful for them. They also appreciate it when the contract is ready, that from top to bottom, they can also explain to some of their employees or whoever will be responsible for the work which is regarding the contract. So it becomes useful for both the parties, for whatever parties who are the stakeholders in there. So second would be, I would say, neglecting the jurisdiction specific regulations. I have multiple examples in there, say GDPR in SaaS contracts, depending on where the companies are operating and what kind of data they are trying to source and from where they are sourcing. Second would be the minimum wages in an employment contract. So it can vary if you are in Delhi, you are in UP, or you are in California, in Florida. Everyone has different kind of laws for the minimum wages. And if you miss on that and you don't figure out that where the client is actually going to work and where he's hiring and where the person will be placed, it will make a lot of difference. And if you miss on that, the client will be paying very hefty fines, and obviously it will have an impact on your trust building also, because this whole field is built on trust, and you need to ensure that everything is according to the law. Third would be, I believe, if you don't have a good communication with your client and don't understand their end goal, like what is the purpose that they need to serve with this contract, then you will definitely make that client suffer in future. Say, for example, He wanted a very simple termination clause where they can end the contract in 15 days and just go on with it. But you thought to add a very difficult process so that either party cannot leave the contract and they follow their obligations to the letter. But your client didn't want that. But you put it and don't explain it to them that this is why I put it. So it becomes a problem once the client actually thinks of executing it and want to terminate the contract. And in such cases, then it goes on for a very long battle. I've handled one of those cases where there was a contract which was drafted by someone else, and the company came to us when there was a breach, and they other party went to the court. So they were already going on for litigation for about 3 4 years. But when I asked them what happened, you said that you wanted to exit very early and you wanted an easy thing. Then why this contract has very difficult termination clause? So they told us that they were not aware that the termination clause was so detailed. They also figured it out when the party filed the case against them. So we had to handle that on the litigation side. But then from that, I learned that you need to have clear communication with your client before going in for the discussion. Prepare your points and write down whatever you want to. It might take some time. You make the client understand that why this is important and they need to give you time. This is the third one. I would say one more I would like to discuss is the four is having inadequate risk allocation. You don't be clear on the data breaches for SaaS contracts or don't have a clear indemnification clause in MSA. It is going to cause you problems. You will not be able to claim damages as you desired whenever the problems occurs. So you need to be clear on the data breaches, and in case data breach happens, what are the process and how do you claim your damages, and same for the indemnification clause for MSAs, and same for NDAs also and other contracts. So these are some of the things. There are a lot more, but I believe these are the first thing that you need to do. It will make you a better lawyer, and definitely you are giving good quality of service that will obviously have a good impact on your client also.
Oh, yes, communication is the key. So is the networking, I guess. As per my understanding, you have already helped more than 10 businesses over the years in United States. How have you ensured the compliance with federal, state, and their local regulations? And how much networking has helped you in procuring these kind of clients, especially abroad? Because it's not easy task. It's obviously something which learner would love to understand that how have you done it? How have you achieved it?
So I have incorporated more than 10 companies in US in different jurisdictions, say Florida, then California, Maine is Delaware, and we have Texas and other states also. Now, while incorporating these companies, the main focus that I always have is after registering one or two companies, I figured out that I need to prepare a checklist which need to be followed in every single case so that we don't miss on important points before setting up the business. How I got those clients is a very different story. I have done a lot of work for a lot of months on a regular basis. Same for LinkedIn and same for some email reach out. So some thing or the other always works, and once it gets you regularly, people figure out that this person does good work and they do reach out themselves also. Now, regarding the checklist, the first thing that I always follow is figure out why and where the client wants to set up his company, his or her company. They might sometimes choose Delaware, they want Texas, and they are stuck on Texas. But once I have a communication or a discussion with them, I figured out that it would be better to choose Delaware because whatever goals that they're aligning to, it would suit better to choose Delaware or some other jurisdiction, because they might Google it and they might talk to some of their friends and they think a specific jurisdiction is good for them. But once they have a communication, then they figure out that, okay, this is my actual need and this is served by X jurisdiction. So it is important to have a clarity on which jurisdiction you want to register, because you definitely want that client to stick to you for long years, and from not only incorporation of the company, but I would say to the growth and whatever work that they do for next couple of years, it is sourced through you only and they only come to you for the legal requirement. If you miss on that and you don't work on their company in a detailed manner, then it will definitely cause problem, or they will only get only one single kind of work from you. Second, I would say is figuring out what kind of company is better for them to register. It should be LLC, C Corp, or S Corp. So it gets clear once you have a communication understanding with them, like what kind of things they need to do, how many employees they want to have, and how big they want to grow, and what is their current budget for this. So once you have a good idea on that, then you'll be able to guide them better to choose a kind of entity which is more suitable to them. Third is once you have the answers to above two, then it is first and foremost important, since you have the jurisdiction and the type of entity that you need to register. You do your legal research, you do your due diligence to figure out what kind of compliances also that are required, what are the documents that are required to be drafted before you incorporate the company. Once everything is ready, you know what kind of documents you need, what documents you need to draft also. Then you move towards drafting all the documents and filing before the state. Most of the states have the option to do e-filing, or in case you don't want to do the e-filing, then you can file through physical process also by sending them an email or through the fax thing. So once you follow the proper checklist and have a idea and what steps comes one after the other, then you will be good. You will be giving good services to your client and they will also be happy. This includes EIN and every kind of thing that happens which is required for the company.
It's absolutely amazing to know that a person is following the checklist in order to make sure that their clients are happy with their work, especially your work. Doing all these things, you have also dealt with various arbitration matters, nationally and internationally both. What do you think is the advantage or disadvantage of arbitration in traditional court during litigation or the new era that has come up, online arbitration, which is happening nowadays very frequently? If you're comfortable enough to share some of the interesting incidents or challenging events, because obviously you cannot take the names, but there are many such experiences which can be not only entertaining enough but inspiring enough as well. So, making that point, I will request you to share if you have any experience related to arbitration or any tech arbitration, because that is something which is not only very upcoming. I believe you also have taken part in such arbitrations as well. So, please let us know about the traditional arbitration as well as the new tech arbitration or IP arbitration and kind of their comparison.
I'm working in the field of arbitration. I've handled a lot of arbitrations, I believe more than for 4 years. And I saw a lot of advantages of it compared to the traditional courts. Like, first off, is definitely if you're considering commercial disputes, then it is very useful. It is faster. Parties are definitely allowed to choose their arbitrator. They can choose a person who have the expertise in that field. If you're considering tech or IPR or whatever this new upcoming fields, then it's very important to have a person who have the expertise in this area, because they will be understanding what difficulty arose and what breach happened and how it can be resolved in a better manner and which party is right in their stance. And the best part right now I feel is the virtual arbitrations that we do. I am very big supporter of virtual hearings and the arbitrations also, because you can just be in one place and attend arbitrations all over the world. I remember I got an opportunity to work as a paralegal in a law firm based in Florida. From there, I also attended an arbitration in US while sitting in India. So it was a very great experience. We didn't have to give too much discussion during the hearing, but we learned a lot just by watching them and how they think and how arbitration are happening here. So it's a different thought that goes on to having a worldwide arbitration. So your thought process changes. But that's why virtual, I believe, is the best thing and it is the future. People need to accept it a lot. Physical hearings are important, they have their importance in their place, but I believe 90% of the hearings should be virtual, and same goes for arbitration also. Now, it's not all hunky dory. Arbitration is having its own challenges, especially say the cost escalates a lot when it's an institutional based arbitration. Definitely, it comes with the benefit of having a quicker decision in your matter, but the cost is definitely high. Second is the limited appeal rights. You have very limited rights to appeal the award, and it is very difficult in situations where the award itself is very poorly given or there are inherent defects in it. You can challenge it, review it, but it goes back to the arbitration. Then in the whole process is to be repeated again, and then you are back to zero. Third would be, I say, especially in the cases of cross-border disputes, and mean not only international but also domestic, because sometimes the property is located in Karnataka and you are fighting case in Delhi. But when you go to execution, you need to go to that state where the property is located. So the execution itself become a battle. I remember I did a small legal research project during my internship. I don't remember clearly the whole case, but I believe in that case there was a state of Poland matter, and they wanted to execute a arbitration award in India in a state against another country because the goods were located in India. They were not delivered to Poland from here. The cargo was stopped here. So now it became a problem because they were not able to execute the award. So the execution itself is very difficult. Now, one of the cases that you refer to, it was a virtual arbitration I did. It was a big project of 9 CR. In that case, I represented a government institution and it was against another company. Now, everything was going online. The party was repairing through from southern parts of India and we were representing from here. Now, everything was going okay. They felt like initially they will be ready to settle the matter and they feel like they did beat the breach and everything was okay. But meanwhile, when they filed their written statement, we figured out that they want to challenge the whole arbitration process because there was a recent judgment of Supreme Court saying the government contracts having arbitration in a unilateral manner is invalid and unconstitutional. But I felt like why this happened? It should not happen. Happened. Everything was going towards the settlement, but they just changed the stance. So I like, oh my God, it's not always hunky dory in this situation also because the other party might be talking good to you and do want to settle, but when they actually are taking their legal steps, they are just going behind your back just to have the case in favor. But we ensured that it worked in our side because I read the contracts, then I have to do the whole evidencing. I have to go through the whole agreement, and then we figure out that since the ICA rules were applicable in that case, and we have a very simple arbitration clause giving rights to both the sides, so we were able to convince the arbitrator that every contract of government does not have a unilateral arbitration clause in itself. You have to read the agreement to figure out. And in that case, we had a simple agreement. So a simple IP matter, tech matter for providing software just took a different side, but yeah, we handled it in a way and the case proceeded in our favor. So it was a good thing. We got the award in our favor. So yeah, it was not small amount. It was more than 9 CR. So it was very big achievement for me also, especially learnings that we got.
You have had an amazing, successful journey. Congratulations, not only on that, but also the learning that you have had through the whole process. It's absolutely fascinating to know and understand all these kind of challenges that you have gone through. But how we overcome all this is what matters. Having said that, all throughout your experience, there have been different variety of national and international litigations, cases, variety of arbitrations as well. How have you gone through these specific skills, or how have you garnered these habits or skills in order to make sure that you go to the right resources, you look forward to certain understanding, and you believe that they are very crucial in order to keep yourself abreast with the current situation or current dynamics of the field, current updates, everything, whatever you do. We would like your advice, or we would like to ask you to make sure that it reaches the masses, not only the masses, but the young professionals who are trying to enter in these fields, especially arbitration and international law, as you are. There are so many of them that you have already been practicing. So we would request you to give us advice, give our learners the advice, how to prepare that certain checklist that you talked about, and in order to make sure that the learners also understand what is the importance of making that particular checklist in order to make their own path and also take inspiration from you.
Yeah, definitely. Because when I was also in my college, I didn't have a knowledge about like I didn't had a clear path where to go, what to do. At that time, you are very enthusiastic and you want to do everything that is coming towards your way. And then when you start doing it, and then you figure out that this is not what you want to do, but you want to do something else. But for me, for college, I was always interested in international legal work. I never thought of how to do it, and my first exposure actually was from an internship that I did in a big law firm in Delhi itself. It is in Green Park. I did a very small legal research project. It was a Spain-based client who want to file a case against some company in India. So that was my first thought. Like a foreign client is also approaching us, and how do you even think of sourcing such clients from outside your field? And because it's literally outside my field, I never thought of even talking to a foreign client and doing work for them. But the pathway that I followed is like just to finding out, doing your legal research first. Try to take a month and search everything that you can. and note down some important fields that are currently in market, which is a growing area like tech law, IPR, patent is also growing, data privacy is there. And there are other things also, say employment law, because people don't focus on employment law. It is an important part, which whenever you are going to set up companies, they would also want you to do employment handbooks or employment agreements. So this is also an important part, including the other things. So first write it down, do a Google search for a while, take a month, and then see what kind of work goes on into a specific field. Pick out 3 or 4 niches, and then see that this kind of work I am interested. Okay, this is interesting. I would love to do patent work. There is a lot of search that we do, and I like a USPTO thing. So definitely you note it down, you make a list of it, and then see in that field what is going on in India and what is going on in international level. So you get a basic idea how to think in Indian perspective and foreign perspective. I was very lucky because I saw an ad of LawSikho when I was first trying to find some international work, and I attended a boot camp. It was a bundle of projects, bundle of diplomas. One is for corporate law, second for US paralegal work and contract drafting. I attended those courses, and from there I built up a understanding, and I learned how to approach a foreign client for legal work. So then I understand that it is not that much difficult, which I was thinking for last 2 or 3 years. But it was a great opportunity also. I implemented every single thing what I learned there. I did LinkedIn, I did Upwork, I did emailing, and I was very clear on path of drafting contracts initially, and then moving towards the section of incorporation of companies. And from there, I wanted to do compliance. And after compliance, I am now moving towards data privacy and patent also. By a few months, I will be adding more and more clients based on that. So I started from a very small point. I did my due diligence of figuring out what the list of fields that I want to work on. Then I found the pathway how to approach clients for international and Indian jurisdictions. And from that, learned the skills that are required to give the work what client is expecting from you to give, and maintaining quality alongside it. And having a presence on social media is also important, because what's seen is what is sold. So basically, as you asked for a checklist, I would say definitely give 2 3 hours on daily basis. Don't skip on it, because people think that okay, if I'm working on a job, then I'll only give 8 hours. This is for you. Consider yourself as your own company. So give more hours to yourself, because this is something that you will build for yourself. And in case you are able to grow also, you will be hiring more people and you're giving them work also. So they will also be a part of you. So give more and more time to you, because this only help you grow in your field and meet a lot of great people all across the world, and you learn a lot. So be ready to give 2 or 3 hours daily. This is bare minimum initially, and then follow the right path first. And the most important is figuring out your niche, and then building your skills in that niche, then targeting clients regarding whatever that you have learned and whatever they require, and then make some changes according to the work that you get, and make sure that whatever work you deliver is of high standards, because that work itself will be your marketing tool. So give good work, they will refer to you good people, and they will definitely hire you for not a single task, but sometimes of the whole company work, like whatever company requires for the legal things, they will definitely come to you. So this is a basic thing that you need to follow initially, and then you will figure out after this, you will find the pathway, and you definitely figure out your future ahead.
Such busy schedule, having variety of litigation and arbitration practices all throughout the globe. How do you keep yourself mentally and physically healthy when you are working in such stressful environment and different time zones? Although it is not created by the businesses or the kind of work that we always do, but it also happens if we or you do not put in the kind of hard work and smart work at the same time. So, how do you actually detach yourself from the current work and relax and then come back again with full force? What has been your strategy all throughout? We would love to understand and take notes of it.
I understand what you said, and I want to add on to it. When you are thinking of international work, that the first thing that I skipped, and some other people might also do, is I forgot that there is a time difference. So there is like 12 hours difference mostly in US, and 9 to 12 hours at least in every country. So even if you are working 5 hours a day or 6 hours a day, it will be in the night. Sometimes it's from 8:30 to 1:30. Sometimes it's from 5 a.m. to some other time. depending on whatever the client is expecting, because you have to work according to their office hours. Otherwise, if you don't want to and you want to just do the project, then also you should be available whole day, because they will be definitely emailing you as per their schedule of 9 to 5 or whatever time. So that shift initially was very difficult for me. I lost my balance all around, because I have course also in morning and then I have to work for them in night. So after 1 or 2 months, I sat down and thought of having a mental clarity that this is going to be way forward. I am giving say 10 hours a day for my work from evening 7 o'clock to say in the morning 3 a.m. and then rest in the morning from 10 to 4 a.m. and then have the remaining hours for myself. Since I don't need to travel much except for my course, most of work is from online. So it is easy for me in that section that I don't need to travel, but I don't waste that time. I use it to add on to my work. Earlier, I was able to do 8, I'll do 10 because 2 hours for travel are saved and I'll utilize it in my work. So I'm happy to do that. That is the clarity I got. And then I figured out, wrote down what things I need to do, what my whole schedule should look like. And I try to stick to it at least 80% of the time or sometimes 60% of the time. That is also a win. So you have that, and sometimes mental clarity is not enough because you also fail in situations. Every day is not a good day. You have low days. So for those days, you need to have 1 or 2 people who are having positive vibes, who understand how you work and why it is all haphazard in your life because you are working in the night and in the morning and every time. So 1 or 2 people are enough because they understand how you think, how you operate, and they will be very supportive to you. Other than that, it's also important to do your workouts because you will be sitting a lot of time and it definitely have a impact on your body. So have 3 to 4 workouts in the whole week. What I follow is 1 week before I see that this is my schedule. The next week I have these many cases and I have these many meetings in the night. And then I'll figure out that okay, this is the schedule. The 2 or 3 hours I have free on Monday or Wednesday or Saturday, Sunday. So I'll use those 4 days for my workouts and especially focus. I would recommend a small tip: focus 1 day on your low back and upper back because you'll be sitting a lot and your low back need to be in a good state for next 10, 15 years or 20 years or the whole life. So you need to do that, at least have one workout on that area. You will feel a lot better, and try it. It's a tried tested method. It do work. And other than this, I like to meditate also whenever I get time. Earlier, I used to have a lot of time. I used to do it every single day, but now it's not possible because of different schedule that I have. But whenever I get time, at least say again 3 to 4 sessions or 5 sessions a week, your mind is always running towards work or family or things that are happening around you. So you need at least 30 minutes to just sit down and calm down, have a clear mind so that you can focus better and your health feels also better. Try silver method. It worked for me, and I recommended 2 or 3 people to this thing, and it worked for them also. So I think this is good. Also, I would recommend people, if they are living with their family, have one meal together in night or day or whatever time suits you. So you have a normal conversation with them, you enjoy time with them, whatever you time you have. And definitely the after mental clarity and all the things that I mentioned, it is good to follow a proper schedule and have time blocks since you will be very busy the whole day. So time blocking is very useful, and you are able to do a lot of tasks in a single day, which people usually take weeks because of the haphazard things that they do in their life. If you are more organized in your work and your schedule, you will be able to achieve more and more in 2 weeks, which other people might take more than a month. So this is the basic thing that I would say to people. And last thing I would say is just persevere. It is a very difficult field, be it in India, be it international. It is genuinely very difficult. You need to persevere. Sometimes it's not always growing. Sometimes it goes down when you are growing, and then you have to be focused. Have the same focus that you had on day one, the same focus that you had when you were growing. So be ready to face whatever challenges that you do, because you are in the field of problem solving. You're solving problems for your client. If you're not able to solve problems for yourself, then you are lacking somewhere, definitely. And obviously, I'm a spiritual person also. So once a week, I try to go to a temple nearby for my spiritual peace and some support for the mind. And the other habits of going outside is I do Delhi tours, visiting some monuments, having a feel of the history. I am a Delhiite, but I travel in Delhi like a tourist because I am so much romanticized with this city and I just love the history that it has. Like 7 cities, it has been capital. for very long time, and it is for a reason. So it's a very important place and it is close to my heart. So I just travel for monuments and I just follow a guide. And I also follow only those guides which are also romanticizing the city just like me, because the way they will tell the story of this place, or even a small brick which is installed in a monument and why it is there, it is just amazing. A small recommendation also, follow Anzip Delhi. He takes you on good tours if anybody is interested. So it's a lovely experience.
Thank you for sharing your thought about before helping someone else, we must learn how to help ourselves. I'm going to take that from you. Then the kind of resilience that you're talking about, that resilience is the key. And the love for your city is amazing. I will also go to the website and check it out. But it's also amazing to know that an engineer turned lawyer is explaining things and exploring the world as he wants and likes. And I really hope that you will keep doing that. We, from our Super Lawyer team, we do wish you well. And thank you so much for being here. Thank you for giving us so much time. It has been fun. All the best. And this has been an amazing interview. Thank you so much, Advocate.
Thank you to you, ma'am, also, because I am following Superliar for a very long time and never even thought of giving an interview. I am very happy. I feel very lucky to have the opportunity that my work has gotten me here, and definitely I am all blessed because my work and the people that I have. And I hope that I grow and I still continue to learn a lot from your team also, and from the posts that you do and from everywhere possible.